Well, good afternoon and welcome to our webinar. This is the impact of executive orders, judicial rulings, new regulations, and more on health and welfare benefits. My name is David Hall. I'm the firm manager here at Hall Benefits Law, and I wanted to extend a special welcome to those of you who are new to HBL webinars. We've got lots of first-time attendees this time around, and I want to briefly tell you about Hall Benefits Law. We are an ERISA and employee benefits law firm. We are relationship driven. Our attorneys are proactive in their approach to ERISA and employee benefits legal compliance, and are experienced in working with companies of all different sizes to optimize benefits programs to attract, engage, and retain top talent, all in a legally compliant manner. So that's who we are. We are so excited again to see so many of you joining us today. Before we get started, I'd like to introduce our presenters. We have three of our senior ERISA legal compliance counsel. Charlene Barnwell is here today, Deborah Andrews, and Rena Felton. So you will hear from them in that order, and then I will tie things up at the end. Before we get started with our attorneys, I would like to go ahead and just talk briefly about the importance of ERISA legal compliance. And look at some stats from the DOL. These are the latest stats. In 2018, there were 1,329 civil investigations that were closed, 807 of which resulted in monetary penalties or other corrective actions. We are not privy to the number of still ongoing investigations, but you can imagine, and I think our attorneys could attest to this, that there are thousands and thousands more of investigations ongoing that will be, some of which will be closed in 2019. And if you are part of one of these investigations, the stats show that there's at least a 65% chance that you're going to be subject to monetary penalties or corrective actions. So our role at Hall Benefits Law is to introduce a paradigm by which we are going to proactively prevent that from happening to you as a plan sponsor, or if you're joining us as a service provider to one of your clients. So digging a little deeper into the stats, obviously the trend is positive. So back in 2016, we had just over $750 million in recoveries collected for benefit plans by the Department of Labor. In 2017, that number rose to just over $1 billion, and last year we've seen that that number rise even further to $1.6 billion. So the trend is upward. I do want to remind folks that for this next slide, the fiduciary liability that plan sponsors have does extend to health plans. And the reason that we as a firm are focused on this is that over the past 2 or 3 years, we've seen a huge uptick in retirement plan focused litigation. And that has set the stage for the next wave of ERISA litigation, which we believe is going to be employer sponsored health plans. The United States spends nearly $4 trillion a year on healthcare, meaning that this is a logical place for the regulatory agencies to go next and for plaintiffs' attorneys to go as they seek ways to fill their coffers. As a fiduciary, you are subject to the exclusive benefit rule, and there's some exposure here on the health and welfare side. And this is the idea that says that as a fiduciary, you need to be watching your copays, your types of coverage, the ways that you're offering pharmacy benefits. As a fiduciary, you need to be looking at offering premiums that are lower rather than higher. And as with any benefit plan, adhering to those plan provisions. So with all that as background, with no further ado, I'm going to turn the program over to Charlene. But before I do that, I'll go through the agenda. So we're going to be talking about the wellness program rule reversal. An ACA reporting update will be given. We'll be discussing a hot topic, association health plans and MEWAs, proposed HRA regulations and HRA expansion, limitations to 2019 health savings accounts, the DOL's voluntary closing agreement process, and employment tax issues. Now, Charlene Barnwell, if you give me just a moment to mic you up, we will move forward with your portion of the program.
Thank you, David. So on December 20th, 2018, the U.S. District Court of District of Columbia vacated the EEOC wellness rule that became effective on January 1, 2019. Just a little background. This date, December 20th, 2018, really marked a dramatic reversal of the EEOC's prior stance, and employers again faced uncertainty as to their wellness program incentives. Here's a little background. For years, it was unclear whether any incentives, such as health plan premium reductions, could be offered to encourage employee participation in wellness programs subject to ADA and GINA, or whether such incentives would make participation involuntary. In May 2016, the EEOC published final rules providing this incentive, whether rewards or penalties could be offered in amounts up to 30% of the cost of self-only coverage. AARP, the American Association of Retired Persons, filed suit challenging those rules, and a federal court found in August 2017 that this limit on incentives was arbitrary and didn't ensure voluntary participation. Fast forwarding, so on December 20th, the court ordered the EEOC to reconsider those regulations, and the EEOC stated they would not be able to issue the new rule that would be effective until 2021. Well, the court determined that the EEOC's proposed timetable was just entirely too slow and vacated the 30% safe harbor incentive. So for 2019 and beyond, employers are again faced with uncertainties as to their wellness incentive programs. This means that employers will need to decide their level of risk tolerance when it comes to implementing wellness program rules. So what I have on the screen is the ways that you can really evaluate as an employer your risk tolerance. You may want to consider, number one, to keep any wellness incentive and penalty programs. But again, this may seem involuntary and in violation of the ADA and GINA rules. Employers may significantly reduce the incentive and penalty amounts below 30%, regardless of employees' income. However, this may decrease the challenge of EEOC, but it may also violate the federal rules, federal law. Employers may also consider eliminating any wellness incentive penalty programs and wait for guidance from the EEOC. So these are just a few options for employers to consider, but we do strongly encourage that you work with an employee benefits attorney to ensure compliance with all applicable laws. Moving on to the regulatory update for the Affordable Care Act reporting. As you well know, the release of the 2018 documents annual reporting documents is another clear message from the IRS that it's continued to enforce the reporting requirements. The good news for employers is that there are no substantive changes to the forms from prior years. So I believe the focus for employers this year is to really continue to be as accurate as possible in your Form 1095-Cs and 1094-Cs, and timely file and furnish your 1095-Cs according to the deadlines. ACA is still in place and carries with it compliance requirements and potential for steep financial penalties. Deadline to furnish Form 1095s to employees was on January 31st, 2019. The IRS extended that deadline to March 4th, 2019. There are two deadlines to file the Form 1094 and 1095-Cs to the IRS. There are some stipulations. If you're filing by paper, you make sure that 1095-C, you're not filing no more than 250 forms 1095-Cs. However, if you have more than 250 1095-Cs, then you will need to file electronically to the IRS on April 1st, 2019. The penalties for failure to meet the ACA deadlines, again, as I stated, can be costly. Here are the penalties. For failure to file and complete an accurate Form 1094 by the deadline results in penalties equal to $270 per form, not to exceed $3 million per year. The failure to file and furnish correct information on Form 1095-C can also result in about $500 per form penalty for employers. But we're pleased to say for our firm that in 2018, we assisted our employers by avoiding and abating more than $2.5 million in employer pay and play penalties assessed for the 2015 tax year. And this is pursuant to the 226J letters that we received. So let's take a look at the Form 1094Cs. 1094C transmits Form 1095Cs to the IRS. ALEs, are also known as applicable large employers, must report required information about whether or not the employer offered minimum essential coverage at minimum value that was affordable. In order for an employer to complete this form, the following items are needed to complete that form. One being the number of full-time employees each month, the employees' names, socials, the dependent socials, the cost of monthly coverage for employee only, confirmation that 90% or more of eligible employees, full-time and full-time equivalents, were offered minimum essential coverage, or just a few items, essential items that are needed when you're reviewing your 1094Cs. The IRS has clarified the proper method for completing the IRS Form 1094C on behalf of a control group. The IRS stated that each member of an aggregated ALE must complete its own authoritative transmittal 1094C. An aggregated ALE also means a control group with 50 or more full-time employees, including full-time equivalents. Here's an example. You have Company A, Company B, Company C. They all share common ownership to a level sufficient for establishing a control group. With Company A, B, and C, their combined employment of 50 full-time employees, full-time equivalents. Each employer is an aggregated ALE subject to the pay or play penalty, and each employer is also subject to the associated reporting requirements and must file its own 1094C authoritative transmittal using its own EIN number. The 1095C form provides healthcare coverage information. Employers should report the following on the form: proof of minimum essential coverage, basically meaning that you are showing proof that the individual was offered employer-sponsored health plan. The employee ID, social security numbers, as I stated earlier, but please keep in mind that spouses do not qualify as dependents according to the ACA rules. When an employer reviews the Form 1095C, make sure you review line 14, 15, and 16. Let's take a look at the Code Series 1, line 14. If at any time in the year an employee is eligible for this coverage, each month needs to be completed regardless of whether or not the employee maintained eligibility or employment. There's some questions to consider: whether this individual was offered coverage, the type of coverage that was offered, months that coverage was offered. Let's look at Code 1A. If your lowest cost plan of employee-only share of coverage was under the federal poverty line, and you offered a plan with minimum essential coverage to the employee's dependents and spouse, use Code 1A and leave line 15 blank. For all months prior to 1H, date of hire, so any months prior to the date of hire, use 1H on line 14, leave line 15 blank. For months employees was enrolled in a limited non-assessment period prior to being offered coverage, use 1H on line 14, line 15, you leave that blank. Code Series 2 is used for line 16 on Form 1095C. Here are some other questions you need to consider when you're looking at line 6, when you're trying to complete line 16. Whether the individual was employed, and if so, whether he or she was a full-time or part-time employee, whether the employee was enrolled in coverage, whether the employer is eligible for transitional relief as an employer with a non-calendar plan year, or whether the coverage was affordable, and if so, based on which safe harbor rule method, which we'll talk about later. Line 16 technically can be left blank, but if the employee goes to the marketplace and qualifies for a tax subsidy, you may be penalized for not offering affordable coverage. For all months prior to month of hire or date of hire, as I stated, use 1H on line 14, leave line 15 blank, but use 2A on line 16. For months employee was enrolled in a limited non-assessment period, you use line 1H on line 14, leave line 15 blank, and use 2D on line 16. For all full months, the employee enrolled in coverage, use code 2C on line 16. Deciding which ACA safe harbor method to use is an important question for employers. Federal poverty line to G, W-2 reporting to F, rate of pay to H. You see where I have to G, that's the federal poverty safe harbor. That's an annual household income for which is a function of the household size, and it is adjusted on an annual basis. W-2 safe harbor code 2F can be the trickiest safe harbor because it cannot be determined until the end of the plan year. While there are methods that an employee can use to gauge that safe harbor, it ultimately cannot be determined until the end of the year. Rate of pay safe harbor H2H. The rate of pay safe harbor is based on an employee's hourly rate or monthly salary rate, depending on an employment status. Best practice has been to undertake the safe harbor test for each full-time employee each month. The Patient Protection and Affordability Act offered Americans a new place to find health insurance, the government-run health insurance marketplace. After the marketplace opened for business on January 1, 2014, the number of insured adults increased. By 2017, however, the number of uninsured people aged 19 to 64 rose to 15.5%. It was clear that not everyone was finding a good plan in the marketplace. A different type of insurance, the association health plan, remained unavailable to many of the uninsured, in part due to ACA restrictions on the type of groups that could form such a plan. However, recent changes have created an environment opening this benefit to more people. And an association health plan is a group health plan, meaning instead of being sponsored by a single employer, a group or association of employers establishes and manages an association health plan. This type of ERISA covered plan is a group health plan and a multiple employer welfare arrangement known as MEWA. Through an association health plan, group, collectives, and small businesses have access to more affordable health care options for their employees. However, AHP, or association health plans, are not required to carry certain benefits required under ACA, specifically essential health benefits packages. As such, AHP have enjoyed greater flexibility in designing benefits package. So under the DOL's final rules, it established alternative criteria under ERISA Section 3.5. It does not replace the DOL's previously issued guidance under ERISA Section 3.5, but adds additional mechanism to meeting the definition of an employer within the meaning of ERISA Section 3.5. This rule became effective starting on September 1, 2018 for fully insured AHPs. January 1, 2019 was for existing self-insured AHPs. And April 1, 2019 is the effective date for new self-insured association health plans that are formed under these final regulations. So again, association health plans provide health coverage to individuals and employees as participants. And under the old guidance, it was difficult to satisfy the DOL's definition of employer. So with that being said, we're going to talk through the criteria that help redefine the definition of employer. The DOL states the first criteria would be to establish a substantial business purpose. It must have one substantial business purpose unrelated to health benefits, such as lobbying and education, with a principal purpose, and it doesn't have to be for profit. The DOL also states that the bona fide employer must require a commonality of interest. That means in the same trade industry, having a principal place of business in the same region that does not exceed the boundaries of a single state or metropolitan area. A bona fide employer is also required to have at least one employee who is a covered participant in the association health plan. Also, the employer is required to have a formal organizational structure. That means some governing body with bylaws and other similar indication of a formality of a corporation. And the bona fide employer is also required to have this control over the association health plan, meaning the control is defined as function and activities, not by the fact that the employer has key officials or board members that have fiduciary statuses. The rules look at how the association health plan is managing from a function and activity. That determines control. And last, the bona fide employer is required to have what's called limited participant eligibility. Eligible participants include current employees, former employees, working owners, self-employed owners, beneficiaries of such individuals such as spouse and dependent children. And again, since the DOL declined to include any specific open enrollment requirements, there may be some flexibility on how the association health plan members can distribute plan information to their employees. So under ERISA, the DOL and the states have joint authority over multiple employer arrangements, including associated health plans. And this is really to ensure appropriate monitoring, regulatory requirements, mechanisms, and also to ensure consumer protection. And employees are relying on association health plans for health coverage. The DOL, under the final rule, supports this joint structure by not reducing the historically broad role of the state by regulating MEWAs, like an association health plan. But I'm going to turn it over to my colleague, Deborah Andrews, to take a deeper dive in the MEWA regulations and how association health plans are integrated with MEWAs. Deborah?
Thank you, Charlene. I think it would be helpful if I started off by giving a little bit of a background on what a MEWA is. And some of the issues that have been involved with operating MEWAs. The main purpose of a MEWA is to give employers, especially small employers, access to low-cost coverage. However, MEWAs have been on the DOL's radar for some time because of their history of abuse and fraud. Some promoters have been marketing MEWAs as an attractive vehicle for providing health coverage. However, their large administrative fees have been paid before the claims are paid, leaving insufficient funds available to actually pay the benefits. So the DOL has indicated that MEWAs are their enforcement priority. So what is a MEWA? Well, a MEWA is an employee welfare arrangement or any other arrangement established to offer or provide welfare benefits to the employees of two or more employers. There are certain exclusions for collective bargaining agreements and rural electric or telephone cooperatives. But the definition of a MEWA requires the participation of at least two employers. So if the employers are part of the same control group, then the plan or arrangement is not going to be a MEWA. It's going to be considered a single employer plan. So the first step in determining whether a MEWA exists is determining whether the employers are part of the same control group or under common control. Now, determining common control can be an extremely complicated process because it is governed by some very complicated IRS regulations. But in general, business entities, the focus is on the amount of ownership interest that's involved. And for tax-exempt entities, the focus is on the control of the governing board. So if your entity has a complicated organizational structure, then you may want to engage counsel to perform a control group analysis to make sure you have a clear understanding of who is in your control group. Okay. So if a MEWA exists, then it's going to be of one of two types. It's either going to be covered by ERISA or it's not going to be covered by ERISA. ERISA is going to cover plans that are deemed to be employee welfare benefit plans as described in ERISA. And there are two requirements in order to be an employee welfare benefit plan. The first requirement relates to the type of benefit that is being offered by the plan, and ERISA lists certain requirements that is certain benefits that are acceptable, such as medical, disability, and death. So if the plan is providing healthcare coverage, then it's going to meet the benefits requirement. The second requirement relates to whether or not the plan is maintained or established by an employer. Now, this has been a major issue, specifically with respect to whether a group or association constitutes an employer. And why does that matter? Well, whether a MEWA is covered under ERISA can impact other issues such as the scope of state regulation, and also it could impact the participating employer's responsibilities. So now I've given a general overview of MEWA. I'm going to turn briefly to associated health plans. An associated health plan, as Charlene mentioned, is a type of MEWA. It's a MEWA that is established to provide health care, and it's not really a new concept. But in determining whether these type of plans or AHPs are ERISA covered plans, there's no dispute as to whether or not it's going to meet the benefits test because it's providing health benefits, and health benefits is an acceptable benefit under ERISA. The issue has always been whether or not it's going to meet the definition of employer. And under the traditional rule, the Department of Labor has required the commonality of interest to include common economic or representational interest among the members other than the provision of benefits. It was a facts and circumstance test. However, geographic location was not enough. The DOL considered factors such as how members were solicited, who was entitled to participate, who actually participated, and the relationship of the members outside of the MEWA. It was often difficult for entities to meet the commonality of interest test. Well, under the new rule, it makes it easier to satisfy the commonality of interest test, as Charlene previously mentioned. And common geographic location is going to be enough. Now, under both the traditional and the new rule, the participating employers are going to need to control the activities and the operations of the MEWA. And control is generally based on facts and circumstances, but one strong indicator of control is the participating employer's ability to elect the governing board of the MEWA. Now, although AHPs can be formed under the traditional rule or the new rule, I just want to mention that if an AHP is formed under the new rule, it will affect the AHP's ability to obtain VEBA status. And VEBA stands for Voluntary Employee Beneficiary Association. Now, a VEBA is a tax-exempt entity under Code Section 501c9 that can accumulate income tax-free to provide reserves for the payment of benefits for its VEBA members. However, the VEBA rules require an employment-related common bond, which is going to be inconsistent with the requirements of the new rules. So when organizing a MEWA, you may want to keep that in mind, especially if you're going to want to obtain VEBA status. Okay, so let's talk a little bit about the application of ERISA. If a MEWA meets the benefit requirements and is considered to be maintained by an employer, then it's going to be deemed to be an ERISA covered plan, and ERISA is going to apply at the MEWA level. Now, what this means is that the MEWA is going to be responsible for the reporting obligations, such as filing the Form 5500. The MEWA is going to file a single Form 5500 on behalf of the participating employers. Now, if the MEWA is not considered an ERISA covered plan, then each participating employer is going to be deemed to have a separate a separate plan for ERISA purposes, and each employer is going to be responsible for satisfying their own reporting obligations, which mean they're going to each have to file a separate Form 5500. But regardless of whether ERISA applies at the MEWA level or the participating employer level, The MEWA is going to be required to file a Form M1 with the Department of Labor. And the purpose of the Form M1 is gives the DOL the ability to monitor the MEWA's operating activities and make sure that it's complying with the rules. So if an employer is thinking about joining a MEWA, it really needs to look on the DOL website to make sure that it has filed its Form M1. All right, let's talk about the application of state law. The scope of state regulation of an ERISA governed MEWA is really going to depend on whether the plan is fully insured or self-insured. A fully insured plan is going to be subject to state insurance regulation to the extent the law sets standards for specified levels of reserves and contributions to satisfy benefit payment obligations. And this is typically going to be met by the underlying insurance company. Now, per the Department of Labor, a plan is fully insured if the benefits are guaranteed under a contract or a policy issued by an insurance company. Now, some courts take the position that regardless of what the state says, the Department of Labor has the final say as to whether or not a plan is fully insured. So for a MEWA that is fully insured, if you want that added protection, you may want to get an advisory opinion from the Department of Labor stating that you are actually a fully insured plan. A self-insured plan is really a plan that is not a fully insured plan. And a self-insured plan is going to be subject to state law, which regulates insurance to the extent that law is consistent with ERISA. Now, if you have a self-insured plan and you're operating in multiple states, you're going to have to comply with each state in which you operate, which can be quite difficult. And some states don't even permit self-insured MEWAs. So most of your MEWAs are probably going to be fully insured because of the high level of state regulation and also the history of prior abuse. If it's a non-ERISA covered plan, then they're going to be subject to the broadest amount of state regulation. They're going to be subject to any state insurance law, regardless of whether that law is consistent with ERISA. All right. Healthcare reform included several MEWA-related provisions. As previously mentioned, MEWAs are on the DOL enforcement priorities because of prior situations in which claims were not being paid by excessive administrative fees and also theft. So in addition to the Form M1 requirement, the ACA provides enforcement rules designed to give the DOL the ability to provide civil and criminal penalties and to halt MEWA operations if there is fraud. There have been cases that have led to jail sentences, court-ordered restitution against MEWA operators. So MEWA operators need to make sure that they are in full compliance and that they can support that they have been in compliance. Participating employers are not necessarily off the hook. Several states, including Georgia, impose joint and several liability on participating employers for unpaid claims, and this is basically an issue for self-insured MEWAs. So a participating employer can find themselves unexpectedly being subject to litigation for unpaid claims. So if you are thinking about joining a MEWA, then you really need to do your due diligence and investigate the financial stability and reputation of the MEWA operator. All right, I just want to end by talking about the MEWA trap. You do not have to intend to create a MEWA to establish a MEWA. A MEWA can be inadvertently created if an employer allows other employers outside of its control group to participate in its plan. This can occur, for example, after a corporate transaction where the employer continues to provide health coverage to employees who transfer to an unrelated buyer. Or it could occur in a reorganization within a control group where certain organizations or entities that were previously related no longer have enough common ownership interests to be considered a control group. I had a client ask me if an independent contractor could be covered under their health plan. And this type of situation raises MEWA issues because the independent contractor, which is a self-employed individual, is considered an unrelated employer. Therefore, you're going to have two unrelated employers under the same plan, and it's going to trigger a MEWA status. So in conclusion, just really need to make sure you understand who is in your control group and make sure you're aware of situations that could unintentionally trigger MEWA status. And with that, I'll turn it over to Rena.
Thank you, Deborah. Now let's switch gears a bit and turn the discussion to focus on some different rules affecting health plans. The first topic that I'd like to discuss has to do with the proposed health reimbursement arrangement regulations, or HRA regulations. In October of 2017, the Trump administration issued an executive order that instructed the Department of Labor, the Department of Health and Human Services, and the Treasury Department, and we'll refer to them collectively as the departments. The instructions were to increase the usability of HRAs, to expand employers' ability to offer HRAs to their employees, and then to also allow HRAs to be used in conjunction with non-group coverage. In October of 2018, in response to this order, the departments issued proposed regulations. And these regulations would expand individual access to healthcare through changes to the existing rules that govern HRAs. These proposed regulations would do a number of things. First, they would propose to remove a prohibition under existing guidance against integrating an HRA with individual market health insurance coverage. If finalized, the proposed regulations would then allow HRAs to be integrated with individual market coverage, provided certain conditions are met. The proposed regulations would also permit HRAs to satisfy certain conditions to be recognized as limited accepted benefits. These proposed regulations also address the implications for premium tax credit eligibility for individuals who are offered coverage under an HRA that's integrated with the individual market health coverage. Now, these regulations would also clarify the status under ERISA of an individual market coverage for which premiums are reimbursed under the HRA. And then finally, these regulations would add a special enrollment period in the individual market for those who gain access to an HRA that's integrated with individual market coverage. It's important to note that the proposed regulations, individual coverage HRA and accepted benefit HRA provisions, as well as other aspects of the regulations, would apply for plan years beginning on or after January 1st of 2020. And also importantly, employers and individuals cannot rely on these proposed regulations unless and until they become finalized. So these next few slides will highlight various provisions of the proposed regulations. The first topic I will highlight is integrating HRAs in individual market health insurance coverage. As a background, health reimbursement arrangement is a group health plan which on its own generally fails to satisfy an ACA requirement that prohibits group health plans from establishing lifetime or annual limits on the dollar value of what's called essential health benefits. This is because standalone HRAs impose an annual limit on the amount of reimbursable expenses. Now, HRAs that are not grandfathered under the ACA also fail to satisfy an ACA rule requiring first dollar coverage of preventive services. As a result of this, HRAs do not provide the required coverage and violate the prohibition on imposing cost sharing for preventive services. However, in 2013, the departments issued guidance that says that an HRA that is integrated with other group health plan coverage would in fact satisfy these ACA requirements. So under the new proposed regulations, HRAs would be permitted to be integrated with individual market coverage if 6 conditions are satisfied. If the conditions are met, then employers could then be able to offer HRAs to employees who are enrolled in individual health insurance coverage. And then also employees could use amounts in the HRA integrated with the individual health insurance coverage to pay expenses for medical care, including premiums for the individual health insurance coverage. Again, this is subject to 6 conditions. Condition 1 says that individual coverage HRAs would be deemed compliant if the arrangement requires a participant and their dependents to be enrolled in the individual market coverage for each month that they are covered by the HRA. This approach would basically allow for integration with both the grandfathered as well as the non-grandfathered individual market coverage. In addition to this, the individual market coverage could not consist only of accepted benefits. So an individual would need to actually obtain the individual market coverage as opposed to merely being able to obtain it. The second condition states that an employer cannot offer an individual coverage HRA to a class of employees if it offers a traditional group health plan to the same class of employees. As a result of this, an employee in a particular class cannot be given a choice between a traditional group health plan or an individual coverage HRA. The third condition is that employers that offer these individual health coverage HRAs to a class of employees would need to offer the same arrangement on the same terms to all employees within the same class. So what this means is that the HRA would need to be offered in both the same amount and otherwise on the same terms and conditions to all of the employees. So an employer can't offer an HRA that's more generous for some individuals based on an adverse health factor. The fourth condition has to do with individuals who are eligible for a premium tax credit on the marketplace or exchange. The code provides that an individual who is covered by individual coverage HRA for a month wouldn't be eligible for a premium tax credit under the ACA for that month. But under these proposed regulations, current eligible employees would be able to claim their premium tax credit as long as they opt out of and waive future reimbursements from an individual coverage HRA, and the HRA is either unaffordable or does not provide the minimum value. And the fifth condition is that the HRA would be required to adopt and comply with reasonable procedures to verify that the individuals whose medical expenses are reimbursable by the HRAs are enrolled in the individual market coverage or will become enrolled in the individual market coverage. So this would exclude coverage consisting only of accepted benefits. This substantiation could consist of two things. They could either receive a document from a third party. So for example, a health insurer could provide a document that demonstrates that the participant and any dependents covered by the HRA are or will be enrolled in the individual market coverage during the year. Or they could simply ask the participant and dependents they can ask the participant to attest that the participant and the dependents are or will be enrolled in the individual market coverage. And then the final condition is that the HRA has to satisfy a notice requirement. And in that notice requirement, they have to inform any participant who's eligible of the HRA's potential effect on their ability to claim the PTC or the premium tax credit. And this would need to be provided at least 90 days before the start of each plan year. The department has recognized in the proposed regulations that some employers may want to offer an HRA that's not integrated. So for example, employers may decide to want to offer an HRA regardless of whether its employees have other coverage that complies with the ACA's market reforms. So these proposed regulations would create an additional category of HRAs that qualifies as a limited accepted benefit, provided certain conditions are met. So to be specific, in order to qualify as an accepted benefit HRA, the HRA cannot be an integral part of the plan. So that is to say that the employer would need to also offer other group health plan coverage for the plan year to the participants who are going to be offered the HRA. The HRA would also need to provide benefits that are limited in amount. So any new amounts made available for a plan year in an accepted benefit HRA cannot exceed $1,800. And this is likely going to increase each year beginning after 12/31/2020. The HRA, an accepted benefit HRA cannot reimburse premiums for individual market health coverage. And then the third condition is that there must be uniform availability. So specifically, an accepted benefit HRA would need to be made available under the same terms to all similarly situated individuals, regardless of any health factor. And when we talk about similarly situated individuals, it's the definition under the HIPAA non-discrimination regulations that would apply here. So the final part of the new HRA expansion that I'd like to discuss is the HIPAA special enrollment period. The ability to implement the individual coverage HRAs could lead employees to request additional access to individual market health coverage, either on or off an ACA health exchange, or they would probably want to change from one form of the individual market coverage to another. So many employers that decide to offer the individual coverage HRA can do so on a calendar year basis, and this would allow employees to enroll in that coverage or either change the individual market coverage during an annual enrollment period. However, other employers may begin to offer the HRAs to their employees at any time during the calendar year. As a result of this, the proposed regulations would allow employees and dependents who newly gain access to this individual coverage HRA to enroll in the individual market coverage or to change from one plan to another outside of an annual enrollment period. The special enrollment period would apply in situations where an employer, after the start of the year, begins offering the individual coverage HRA to its employees. And then the new special enrollment period would also apply to individuals who were hired after the start of the calendar year. The regulations do not address other special enrollment issues that come up under HIPAA, such as if there's a change in marital status or a change in the number of dependents and things like that. So hopefully, once these regulations are finalized, we will probably get some answers to that. The coverage effective date for a special enrollment period would be the first day of the first month following an individual's plan selection, and the new special enrollment period would also be available 60 days before an individual actually gains access to an individual coverage HRA. So I also would like to point out that when these proposed regulations were issued, the departments sought comments on a lot of open questions that will presumably be addressed when the departments actually finalize these regulations. So for example, the departments requested comments on whether the $1,800 limit on accepted benefit HRAs was an appropriate amount. They also wanted to know, they sought comments on whether the limit should be higher if the HRA actually covers dependents. The deadline for submitting comments has passed, and so we're currently awaiting the final regulations. Now, the agencies did not fully address how the proposed rules would work with the ACA's employer mandate. Additionally, the proposal included some options that could or would violate existing non-discrimination rules that apply to HRAs and other self-insured health plans. In November of 2018, the Treasury and the IRS issued this notice, which is called Notice 2018-88. And this notice addresses certain follow-on issues that are related to the proposed regulations. The notice confirms that the employer would satisfy the A penalty by offering its full-time employees, including full-time equivalents, an individual insurance HRA. So just like with other employer-based coverage, this is true whether or not the individual insurance HRA is affordable or provides minimum value. Avoiding the B penalty is a bit more complicated because the individual insurance has to be affordable and provide minimum value. So coverage is generally affordable if the employee's cost of self-only coverage is less than a certain percentage of the employee's household income. For 2018, it was 9.56% of the household income, and that's going up to 9.86% in 2019. When an employer offers a traditional health plan to its employees, the employee's cost is easy to determine because the employer sets it. However, offering an individual insurance HRA inverts that calculation. That means that the employer is providing its contribution, but it may not know what the employee is actually paying for his or her individual market. To address this issue, the IRS is proposing a series of options to determine the cost of coverage. So they've issued about maybe 4 options. These would be the employee's actual contribution towards the cost of individual coverage, the worksite safe harbor, and this is what the IRS calls the location safe harbor, the prior calendar year safe harbor, and the first day of the HRA year safe harbor. In addition to the ACA employer mandate, the Notice 2018-88 also talks about possible violation of non-discrimination rules. Under existing non-discrimination rules, HRAs generally cannot provide greater benefits to highly compensated individuals. And then also the maximum amount available for reimbursement under an HRA cannot vary based on an employee's age and other factors that employers might want to consider. Violating these rules would make the HRA reimbursement amounts taxable to the highly compensated employees, which is, of course, as you would imagine, very undesirable. The proposed rules would allow amounts to vary based on classes of employees and increase based on an employee's age. If the IRS guidance is finalized, it would mean that individual coverage HRAs would not be discriminatory as long as employees in the same class who are the same age could receive the same maximum reimbursement. However, the notice also reiterates that an individual insurance HRA that only reimburses for insurance premiums is not subject to the non-discrimination rules. So this is based on existing regulations and is unlikely actually to change. So switching gears again a little bit, just wanted to highlight that the 2019 HSA contribution limits were released. It looks like they have all increased with the exception of the minimum deductible, excuse me, and that's going to remain unchanged for 2019, and it's at $1,350 for individual coverage and $2,700 for family coverage. So again, it looks like the regulations that have been issued increases these contribution limits for the 2019 year. The last bit of information that I wanted to leave you with is a new voluntary closing agreement process from the Employment Tax Department of the IRS. And this is a new process. It's basically a voluntary administrative process, and it allows for certain employment tax issues that did not involve worker classifications. It allows them to go through this process to correct errors for which there is no current form available that would allow employers to make corrections. What's important to note is that the IRS will consider requests for voluntary closing agreements that arise from this new voluntary closing agreement process. It's called the VCAP. Whenever it's advantageous, to have the employment tax issue permanently and conclusively resolved. And then the employer can demonstrate that there is no other form or other return procedure that would allow for a prompt, permanent, or conclusive resolution of a particular issue. And it's also been determined that entering into the closing agreement wouldn't prejudice the interests of the government. So this is welcome news for many employers, especially those employers who have experienced issues that have arisen relating to their health plans. For example, we had a client who offered a high deductible health plan with an HSA, and where the deductible amount was $1,500 for individual, $3,000 for family. The employer ended up applying an embedded deductible so that once the individual deductible was hit for the family, they decided to have the insurance company to go ahead and kick in and start to pay for the medical expenses, which was actually an operational failure, and there was no way to correct this. And so now through the VCAP process, the correction is allowed where the employer can actually pay taxes on the windfall amount for each affected participant, and the participant are not taxed on the benefits that they receive. There is no specific form required for use in requesting consideration for a VCAP, but all requests has to include at least all of this following information. And so the biggest thing that you would want to that we want to point out is that there's a lot of detailed statements that this process is requesting. So you have to have a detailed statement addressing why, what happened, what was the error, how the company is proposing to correct the error, and that why there is no regular corrected return that's able to be used. And so this, again, is welcome news for many employers, especially those with issues concerning health plans that we haven't seen in the past.
Thank you, Rena. So just as we close, we have a couple of minutes. I'd like to address at least one question to our attorneys, and we'll see if we have time for more than that. But from the plan sponsor perspective, Charlene, you mentioned the IRS 226J letters, and as we in this room know, those came fast and furious for the 2015 plan year last year, and we're already seeing those show up in mailboxes of plan sponsors for the 2016 plan year, and we don't see that slowing down. If I'm a plan sponsor and I haven't received that letter, does that mean that my health plan offers minimum essential coverage that is affordable? In other words, does that mean that I am in compliance?
Good question, David. And I would say that would depend. Actually, the first thing would depend on what year the IRS is currently reviewing. Although the IRS is currently reviewing 2016 tax information reporting, it doesn't mean that your reporting is actually compliant. The true answer to this is if you didn't receive a 226J, that means that employee or that individual may not have received a premium tax credit at that time for that plan year. If the employee or the individual did receive a premium tax credit, that meant that individual, either employed or was previously employed, alerted the marketplace that they needed healthcare coverage that was affordable. And they're also and another way of saying this, that the employer coverage was not offered and was not affordable. It depends. Either and that premium tax credit triggers the IRS to review the company's 1095Cs and the 1094C. It generates a letter with an assessed penalty for either one, failure to offer minimum essential coverage with minimum value under Section 4980HA to at least 95% of the full-time equivalents and dependents, where there's a penalty that's attached, or there's a failure to not offer affordable coverage under Section 4980HB to employees to an individual. These penalty, the A penalty or the B penalty, are not assessed every month together as either an A penalty or B penalty. But the bottom line is it depends on whether that individual actually received a premium tax credit.
Okay, great. And then for Deborah, we all know the Form M1 is an annual report that has to be filed by a MEWA. Could you tell me what the penalty is if you don't file that form?
The current penalty amount is close to $1,600 a day, so the penalties can really become significant. But I do want to mention that unlike the Form 5500 reporting requirement, there is no delinquent filer program to reduce the penalties if you don't timely file a Form M1. So you may be able to informally try to contact the DOL and negotiate a reduction in the penalty. However, there's really not going to be any guarantee, especially because MEWAs are so heavily scrutinized.
Thank you. So out of respect for the time of our attendees and our attorneys, thank you, by the way, ladies, for your time today. I'm going to wrap things up, but I did want to remind you that at Hall Benefits Law, we're focused on proactive legal compliance when it comes to employee benefits and ERISA. So some of those examples would include counseling on proper reporting and disclosure notices, as you see on the slide before you, review of benefit plan administrative services agreements. We highly encourage plan sponsors to have your administrative services agreements reviewed by counsel. We will counsel you on cost-efficient, effective plan design alternatives, and we really want to address ERISA legal compliance issues before they become, a $1,600 per day or more or less, depending on the issue, costly legal compliance error. So the other thing at Hall Benefits Law that you should know is that we are active in the plan sponsor community, educating the plan sponsor community whenever we have the chance. And one of the ways we do that is through social media. and through our website. So we would appreciate it if you have not already done so, signing up on our website. We'll send you a monthly HR alert in the form of a newsletter that will have details about upcoming speaking engagements, opportunities to engage with our attorneys, both in and out of the Hall Benefits Law ERISA Learning Center here in Sandy Springs. And by the way, if you're out of state, don't hesitate to reach out. We work with clients in 25 states, and we're adding clients every day. So we look forward to working with you. And please follow us on social media. If you would like to ask additional questions based on today's presentation, you can email me at dhall@hallbenefitslaw.com. Or if you'd like to talk with me about setting up a meeting with one of our attorneys, our team would love to talk to you. My direct number is 404-731-6623, or you can reach out to our main number, 678-439-6236. We hope you'll all join us on Thursday, May 16th for our next webinar, where our focus will be retirement plan legal compliance. So with that, I'll wrap things up, and we really appreciate your presence today, and we look forward to seeing you in May. Thank you.